Rise. The Honorable Chief Justice and Justices of the Supreme Court of Ohio. Hear ye, hear ye, hear ye. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
You may be seated. Good morning, ladies and gentlemen. Before we begin our oral arguments this morning, you will notice that we have Judge Pietrkowski sitting from the 6th Appellate District, who will be in place of Justice O'Neill for all three cases this morning. We will begin with our first case, 2016-1629, Charles W. Thomason versus Carol J. Thomason. For the appellant, Mr. Stafford.
Good morning. Chief Justice O'Connor, may it please the court, my name is Joseph Stafford. I, along with my associate, Nicole Cruz, represent the appellant Carol Thomason. In this matter, it involves a divorce case. 2 days prior to the scheduled trial on the court date, the court appointed a guardian ad litem for my client without the opportunity of notice prior to the order being issued, without a motion being filed. The order did not specify that my client was incompetent. The order did not indicate the reasons for the trial court to issue the order. Under the circumstances of appointing a guardian ad litem, normally...
Before we get there, can you tell us why it's a final order?
Yes, I would direct the court to Ohio Revised Code Section 250502B2, in which it is a substantive right of my client that is being affected, and also it's a special proceeding being a divorce case.
Which substantive right?
It is a right in terms of having her judgment and her wishes being substituted by that of a guardian ad litem. In this particular case, what happened was the court appointed a guardian ad litem, didn't set forth any responsibilities for the guardian.
I understand that, but what about Bell versus Mount Sinai? Do you want us to overrule that case?
Well, in reference to this particular case, we believe that if, in fact, you're going to appoint a guardian ad litem for an individual, that there must be a hearing.
That's not really my question, though. So Bell versus Mount Sinai, which is the case on what a substantial right means, says that it only affects a substantial right if the party seeking review will be denied effective relief in the future, meaning that there can't be an appeal later on that corrects the issue. So I guess my question is, are you asking us to overrule that case?
In effect, we are. The issue in this particular case, you would go through a divorce case, have a litigant's opinions, beliefs, and judgment being substituted by a guardian ad litem. In this particular case, the trial court did not set any parameters upon the discretion of the guardian ad litem. A divorce case affects most individuals on the most fundamental nature. It is a traumatic experience for most. This case involved a marriage of over 30 years. My client was involved in an abusive relationship. She came before the court seeking a divorce. She was the defendant in the divorce case.
But again, aren't there orders all the time in divorce cases that do things like that, they can't be appealed till the end?
Well, in this particular case, the court appointed the guardian under 75
but you just keep telling me why it's wrong. Tell me why it's a final order.
It's a final order because it affects my client's most fundamental right, and that is to be heard, put on the testimony that she desires, call the witnesses that she believes that are important.
Would she be precluded from doing that by having a guardian ad litem?
She would, because...
You wouldn't be able to call witnesses on her behalf?
Well, the guardian ad litem would be up to the guardian to make that determination.
Well, it's not a guardian. There's a difference between a guardian and a guardian ad litem. The guardian ad litem is an auxiliary. The guardian, appointed guardian, and domestic court doesn't have the ability to appoint a guardian, but a guardian stands in the shoes and instead of the individual. It's not quite the same.
Unfortunately, the trial court did appoint a guardian ad litem pursuant to Civil Rule 75B. The correct procedure would have been appointing a guardian under 17B of the Ohio Rules of Civil Procedure. I agree with you, the technique that the trial court used was improper, But under the circumstances, in order for my client to seek relief, she would have to try the case. She would then, if she opposed what the guardian did, take the matter to the Court of Appeals and seek relief there. The process would be very difficult and very time-consuming. I would like to direct the Court's attention to the cases out of the Supreme Court of Washington in 1952 in the matter of Graham versus Graham. The Supreme Court of Washington indicated that a person before a guardian or a guardian ad litem is appointed must be afforded the right or opportunity to, in fact, have a hearing. In this particular case, no hearing, no notice was actually afforded my client.
Does the appointment of the guardian ad litem preclude your representation of your client?
It could. Under the circumstances, the guardian in this particular case could terminate my representation. In effect, the guardian appointed or the guardian ad litem appointed could in fact affect my client's choice to the right of counsel.
Did the trial court, in appointing the guardian ad litem, address the issue of who would pay for the guardian ad litem?
The court did not. The court initially set forth in the order that there would be a retainer paid or amount deposited with the clerk, but did not indicate at the end of the day who would pay for the guardian ad litem.
Who was to make the deposit to the clerk?
The husband was in this particular case.
Now, your appeal here, is that opposed by the husband in this case?
There was not a brief filed.
Okay.
In particular, if we look at other states, the Supreme...
Okay, before you do that, I mean, I'm more worried about our law in Ohio. Wilhelm Kissinger versus Kissinger, a case from the Supreme Court. Are you familiar with that?
I am to a certain extent.
Okay. In that case, we said, in a divorce case, so a special proceeding, we said the denial of a motion to disqualify counsel was not a final order because it could be remedied on appeal. Why is this any different? I mean, in that case, you have someone going through a trial with counsel who they shouldn't be there, or they think shouldn't be there. The court said, "Well, it's okay. You can do the trial over." Why is if you vindicate that right on appeal? Why is this any different? I can't get past that. So you have to explain it to me.
Okay. Let me see if I can take another shot at it. In reference to this, the litigant, her judgment would be substituted by the guardian ad litem.
I understand that, but then you have an appeal. It's reversed. It goes back, and there's no guardian ad litem, so it could be remedied on appeal. You could have a new trial.
What information could my client possibly present to the court to challenge the guardian ad litem?
What do you mean?
Well, if...
You could say on appeal what you're arguing right now, that the guardian ad litem shouldn't have been appointed, go back, have a new trial. That's what we do all the time.
But my client would have no opportunity to present evidence. Her voice would be stifled. The guardian would pick and choose.
But if you prevailed on appeal, you would get a new trial. You would have all those opportunities.
There would be no evidence in the record of what my client's position would be. The guardian ad litem would have the opportunity to pick and choose the witnesses called.
One of us is really missing something here, because if you get a new trial, you have that opportunity to do that again. That's the point.
If we appealed to the 8th District Court of Appeals, we'd have to set forth information in the record that supported our appeal that the guardian did something wrong.
Why wouldn't you be setting forth the exact same thing you're trying to set forth today? What would be the difference?
The guardian would choose what witnesses would be called, what evidence would be presented.
Counsel, where do you see that as the role of the guardian ad litem to preclude you from presenting witnesses at trial?
In the specific order that was issued, there were no responsibilities that were listed out or set forth by the court.
Right.
The guardian ad litem takes the role of the individual presenting the...
No, the guardian ad litem doesn't do that. A guardian would, but that's not it. The guardian is to voice the best interest of the individual that they are the guardian ad litem for. Usually, obviously, this provision is for children. I don't know why it was used and I think that, I think that it's curious at best. But the role of the guardian ad litem is not to do your job. The role of the guardian ad litem is not to muzzle your client.
But before we even get to the role of a guardian being appointed, the question is, Why was a guardian appointed? There has to be some evidence.
And that's all appealable. And the fact that she didn't have a hearing, the fact that the 75.B doesn't apply to adults, that's all fodder for an appeal. But as Justice DeWine is saying, you have the remedy of if the trial court got it wrong and there's a final appealable order, then the appellate court can correct it. And the arguments you're making about the lack of notice and lack of due process and hearing, et cetera, absolutely, I'm not going to presume to pre-rule on it, but those are pretty solid arguments. So, you've got an avenue here.
Well, the problem that you have then, in any given case, if a jurist felt that a litigant was stubborn, not doing what the court felt was best, the court could then, without hearing, without notice, appoint a person a guardian ad litem, or a guardian.
Until an appellate court disposes of this case, when it's gone through the proper proceedings to make it a final appealable order, and then it's appropriately before an appellate court.
Then at every given opportunity, then any litigant would be subject to having their will taken over by a guardian that would be presumably there for the person's best interest. And then they would always have to go through the appellate process if the court appointed a guardian ad litem or a guardian for this person.
Have you ever heard of this happening before?
I have not.
Any jurisdiction? Do we have any indication that a guardian was a guardian ad litem, and I want to use that term. You keep using guardian, but that's not correct. A guardian ad litem was appointed in any other jurisdiction in Ohio that you're aware of?
For an adult
without a hearing.
I am unaware of that.
Okay.
The difference is there's a guardian ad litem that's specifically for children under 75. The court used the wrong civil rule. It's under Civil Rule 75 or 17B for the appointment of a person that's declared to be incompetent. But at the point in time, the person must be declared to be incompetent before a guardian is appointed for an adult individual. In this particular case, there's no adjudication that my client was declared to be incompetent.
Counsel, was there an objection on the record
to this? The order came out 2 days before we were scheduled for trial. We had prepared for trial. We issued our witness list. We submitted our documentation for trial. And 2 days prior, we received the order. We immediately sought relief in the 8th District Court of Appeals. A stay was granted by the 8th District. It was briefed, and then the court determined it was not a final appealable order, citing cases under 75B for the appointment of guardian ad litems for children.
Let's say that we agree with you that it's a final appealable order, and that this should not have occurred without some proceeding. What does that proceeding look like in your view?
Well, there would be notice that there would be a hearing. There would be
what's the evidentiary standard?
Well, it would not be upon my client to prove competency. The evidentiary standard would be a preponderance of the evidence that she was incompetent and incapable of understanding the nature of her divorce proceedings. Just because a person can be declared to be incompetent, there are decisions from other jurisdictions that look at the fact that the person still could understand the nature of the divorce proceedings and still be incompetent and not have a guardian appointed for them. So the burden of proof would not lie with my client to prove that she's competent. And then whoever would challenge the competency of my client would have to put forth evidence concerning that she was incompetent. She would have the right to call witnesses, present a defense. And then if she would lose that hearing, the court would set up the parameters for the appointment of a guardian and what the guardian was to do.
Was this order promulgated on behalf of a movement?
It is not. The court, sua sponte, did it on its own.
What was the precipitating determinations that would have led the court to have done something like this?
We have nothing in the record to indicate that.
Well, don't we have in the record that she was subject to a conservatorship?
Yes, she was, but in that particular case, she was found to be competent, that when the divorce case started, she was having trouble with the demise of a 30-year marriage. She was dependent financially upon her husband. She had counsel appointed to help her manage her financial affairs. That was the extent of it. At the point in trial, the conservator really wasn't doing very much.
But the conservator is is a party to this case.
Court named the conservator as a party sua sponte also. Without notice, the court appointed. We did not object to that, but we did object when the court appointed, in this particular case, a guardian ad litem, because we did not know the scope of what the responsibilities would be for the guardian ad litem. And in fact, we worried that he could terminate counsel. In this particular case, my client was represented by counsel at all points of the proceedings. At no point in time did we request a guardian be appointed for our client. The court took it upon itself, appointed a guardian with no parameters on how we are to work with the guardian.
And that was not pursuant to a motion by the conservator or by the opposing party?
Was not by motion by anyone.
Counsel, is it your belief the guardian ad litem could settle the divorce case without your client's approval?
Yes.
Why? What's the basis for that?
Well, a guardian, if it's under this, if you're taking this guardian as truly under 17B, then there's an assumption.
As a guardian.
As a guardian, there's an assumption my client's incompetent to make her own decisions, and therefore the guardian would be vested with the responsibility to settle the case, could settle the case, and my client would be foreclosed on appealing it to the Court of Appeals.
But under 75B. That's why I'm asking the question.
Well, 75B is clearly inappropriate. That deals with children and serving or protecting children. So I assume the court just made a simple error and was appointing the guardian under 17B. Although the record does not indicate that, it seems that would be the best channel or venue for the court to appoint a person to be, or appoint a person a guardian ad litem. But first, in order to appoint the person, you must declare them to be incompetent. In this particular case, there was no declaration that my client was incompetent. There was no declaration made by the trial court that, in fact, she needed a guardian ad litem. The court appointed a guardian ad litem, using the terminology of the order, on the trial court did it herself. We have no objection with the jurist. She's a very fine jurist. We just object to the procedure used because my client does have the right to have her voice heard in her divorce case. The guardian in this particular case could, in fact, settle her case, could put on different evidence that she would want to be put on in the case, and my client would have no ability to put forth evidence to take it to the Court of Appeals to challenge what the guardian did. The guardian would make the decisions on what evidence would be made or submitted to the court, what experts would be used, and what the claims would be made on behalf of my client.
Does your research show that in either the juvenile or domestic courts where guardians have been appointed pursuant to the proper rule, it's ever been determined to be a final appealable order?
Our research does not indicate that. This is why the case is so important. It's a matter of first impression pursuant to our research looking where there is a...
Say it's a matter of first impression as to the final appealable order issue or as to the appointment by using a rule that doesn't seem to apply to your case. Which is
well, that too.
Which is the
matter of first impression is whether or not a person can have a guardian appointed without declaring the person to be incompetent. In this particular case, there was no finding that the person was incompetent. The case of first impression is that normally in the case law you have some issue of the person being incompetent, either mental health, professional issues, emotional instability.
I think we all understand the substantive issue, but to go back to what Justice DeWine has spoken about, the only ruling from the appellate court here is as to the finality of that appointment.
Correct. And the appellate...
So is the incompetent issue before us, or is only the finality issue before us?
I believe both issues are before you. The reason why we challenged the Court of Appeals decision was they used the case law under 75B in reference to the appointment of a guardian ad litem for children. The law is settled in reference to that, but it's clearly the wrong statutory or the wrong procedure that
So you're saying the basis of the appellate court decision is grounded on the wrong rule?
Correct. If you look under 17B, the case law, under that, you normally, in order to appoint a guardian, you must declare the person to be incompetent. In this particular case, there was no finding, no information, no evidence of that. So the reason why we believe it is a substantive right under 250502B2 is that because it is such a fundamental nature and the lack of guidance from the trial court on the ruling, to go through this trial and have these arguments and fights is going to be extremely difficult. If the guardian chooses to terminate my representation as the justice...
I think we have it. Thank you, Mr.
All right.
Stafford. Appreciate it.
Thank you, Mr. Stafford. You've used your time.
Thank you very much.
We'll take the matter under advisement, and you'll be notified of our decision.